A new law is being proposed by a Member of Parliament that would require all employers to fairly distribute tips and gratuities among their workers. This is the Employment Allocation of Tips Bill, which deals with tips, gratuities and service charges and how the employer must deal with these. Because many people have concerns over the employer, the restaurant or whatever it might be, keeping the tips that are supposed to be going to the workers. I certainly know that in the past I have deliberately paid tips in coins and notes so that it definitely goes to the person that I intended it to go to and not just retained by the business. But apparently in recent years, because more and more people pay by cards, it has made it much easier for businesses to retain those tips rather than distribute them among its staff. In part 1 of the bill, it deals with qualifying tips, gratuities and service charges, and it explains that an employer received tip is an amount paid by a customer of an employer by way of a tip, gratuity or service charge, however described, which is received upon its payment or subsequently by the employer or an associated person, or is received upon payment by a person under a payment arrangement made between the employer and that person. Contrasting with a worker received tip, which it describes as an amount paid by a customer of an employer by way of a tip, gratuity or service charge, however described, which is received upon its payment by a worker of the employer and is not subsequently received by the employer or an associated person. Section 2 deals with how tips must be dealt with. It says that an employer must ensure that the total amount of the qualifying tips, gratuities and service charges paid at or otherwise attributable to a place of business of the employer is allocated fairly between workers of the employer at that place of business. And where a worker is allocated an amount of employee received tips in accordance with that subsection, that amount is payable to the worker by the employer. And in determining what would be a fair allocation of qualifying tips, gratuities and service charges under this section, or section 27E, which is non-public spaces of business dealt with separately, regard must be had to the relevant provisions of any code of practice issued under this part. So in other words, this bill is going to regulate how an employer will deal with tips received by the business or by the worker and allocated fairly between workers in accordance with the rules with this proposed legislation. The bill also goes into detail as to when tips must be dealt with, and it provides that it should be no later than the end of the month following the month in which the tip, gratuity or service charge was paid by the customer. It also deals with agency workers and the eligibility of agency workers to receive a fair amount of tips. It also requires that there'll be a written policy where qualifying tips are received by the business. It will also require that adequate records are kept. It will also provide for enforcement dealing with such tips within the Employment Rights Act, inserting into that act complaints to an employment tribunal about the payment of tips to workers. Going on to say, of course, that if an employment tribunal finds that a complaint is made out under this section, that it must make a declaration to that effect, and in the case of a complaint under the section, make an order requiring the employer to deal with qualifying tips that were paid or otherwise attributable to the business in accordance with this act, and in the case of an agent, make an order requiring that the agent make a payment to the eligible agency worker of the amount that the agent was required to under the section in the Act. The bill also details a code of practice, a procedure for issuing the code of practice, consequential revisions of the code of practice, failure to comply with the code of practice, and so on and so forth. So I will place a link to the full bill in the description below of this video, but I for one think that this should really be a case of common sense. If a customer pays a tip or gratuity that is designed to be for any particular worker or each of the workers equally, then that's what really should happen. But as we all know, some businesses may decide to keep those tips, and so this proposed law would seek to eliminate that, or at least where it does continue to happen, make it something that a tribunal can look at and make a declaration. So answer me this in the comment section below. If your place of work is one that relies on tips and gratuities on a regular basis, or even service charges, do you rely on those as part of your wages, and are you at any time worried that your employer doesn't pay them across to you? Are there times where you believe that your employer is not paying them across to you? Have you made a complaint about it? Have you discussed it with your manager? If so, what was the response and what was the outcome of that discussion or complaint? Have you been dismissed from your employment because you raised such complaints? Because even without this bill, you might already have a valid complaint, but certainly with this bill, if it becomes legislation, and that is the reason that you've made a complaint, it will certainly be a provision that an employment tribunal can look into. If you have any complaints and any difficulties with your employment or employment complaints, do feel free to look up our formal contact in the description below, which is clerks@shensmith.com, and we will see if we can help you. But as always, thank you for watching this video. Please do like and subscribe, and I'll see you next time.